How's it going? Andy Contiguglia here, bringing you your legal lessons in business. I'm really going to sort of niche down a little bit today and sort of cover a topic that I think is really important. It's part of the interview that I did with Joey Kornerman and the School of Motion podcast, which if you hang out long enough for this week, is the podcast is going to be out live on Thursday. So I'm hoping you'll all chime in and take an opportunity to check out the podcast later on. But I wanted to take this opportunity and really niche down to a specific legal issue that I see come up a lot in whether you own a business and you're utilizing development services of a designer or a web, somebody designing your website, or you hire somebody to create logos for you, or in fact you are a designer and you do the creation, you do the website development, or you do the designing of websites and logos. Really what happens at the end of the day is who owns this intellectual property at the end of the day. And in my interview with Joey Kornerman, we talked about this issue really in light of the question, hey, who owns the raw files in the design process at the end of the day? So enjoy this legal lessons in business. If you like this channel, please subscribe. I'm real curious if you could leave some comments down below here. What legal issues have you come up with in your designing or in your business when it comes to designers? Love to be able to chat with that as well. So enjoy. I look forward to hearing from you later. Take care. Good luck.
Questions that recently came up, which is, hey, who owns let's see, I can design the logo for you, or I can design the animation for you, but who owns the raw files at the end of the day? Who does that get to go to? Does the designer get to keep it, or is it part of the intellectual property that needs to be transferred to the other person, to the customer that they're doing? So those are the types of details that you can work into a contract that you can really sort of draft favorably to yourself, that your client will get the ultimate product, but you get to keep the raw files, or that you want to maybe get a license back, so to speak, that you can use what you created as part of your portfolio for other people to look at to see what you're capable of doing. If you were to give over all copyright interest in it, you would not be able to do that kind of thing. So, giving yourself back and, a license to, be able to use what you have created for your own marketing purposes, for your own portfolio purposes, that's something that's really important to be taken into consideration too. Absolutely it is. Absolutely. You have put out the offer, which is your scope of services, the details of what your expectations are from your standpoint in terms of what you are going to do. And then it also sets forth the expectations of your client and what they are supposed to do. I'm going to do these list of things, A through G. And when I'm done with it, you're going to pay me $2,500 for completion of these services. Sign here to agree to these terms. Boom. That's the offer, your offer, their acceptance, the exchange of consideration, which is the exchange of those promises, the exchange of money and the exchange of services. You've got a valid agreement there. Absolutely, that has everything in there. And that's really what I'm suggesting that your freelancers do, is put together a deal memo for every deal that they do and get the opposing side, get the client to, here I'm talking in litigation terms, get your client to sign off on this so everybody understands the nature of what everyone's obligations are. And you could certainly create a form contract or a form letter where you're just sort of changing the scope of services, you're changing the price, you're changing the due date. But it's really important to really have that dialogue with your client, not only to build a relationship with him or her, but to make sure everybody's on the same page concerning the obligations that each party is expected to do. Well, that's a good question. If it's not in the contract, then you're going to have a real hard time enforcing those extraneous aspects of it. So the more detail you can put into that contract, the better it's going to be for you, and the better it's going to be for your client, actually, because then everybody is on notice as to what they have to do. So when, if you're just putting forth the deal points, I'm going to animate, it's going to be a 1 minute short, it's going to include these items, you're going to pay me, and something real simple that you can put in there, which is I'll deliver it to you once you pay me. Or what you can do is, and that's really sort of the hard thing to do. And there are ways that creative people can protect what they have put together by putting like watermarks, across the, across the image that says this is a draft, or created by Contiguglia. So that way nobody's going to be able to take it and put it up on a website without giving you credit, and people will see that hasn't been paid for. But those are the types of things I think you can do to protect yourself. But getting back to the contractual agreement, you need to really define those extra pieces of it, because a deal memo isn't going to really include those things, because deal memos typically are real short and basic. If you can elaborate on it and create it into a more detailed contract and include those, I think you're better off protecting yourself that way.